Thanks. Oh, good. Yeah, exactly. It's great. I'll sit over there. Process. Yeah, good. We'll get started. That's the first time I touched that button, and now I know what the button is for. A very good afternoon, colleagues, friends. Thank you very much for joining today's discussion. And once again, a very, very warm welcome to this space to discuss gender justice and the Crimes Against Humanity initiative, a topic very close to our mandate at the Women's Initiatives for Gender Justice that I have the great honor to be a part of. What we will be doing today is discuss some of the gender provisions that we are discussing in the context of these negotiations. We will be hearing on more of the substantive, and I say more of the, because we had quite a few discussions over the course of this week already in the context of the ASP on the Crimes Against Humanity negotiations, the convention, the mechanisms around that, how to involve civil society was a discussion that we had yesterday, how to involve and what discussions to have with our partners at the state party level, and today we will be focusing on just that for gender justice. So I'm deeply grateful to our long list of co-organizers, and particularly the UK. Thank you very much for being with us and for providing us with a little sustenance here on one of the last days. Let's hope that this is the last day of the ASP, which is also the reason why we moved rooms, because the budget negotiations are being, let's say, concluded. We need to manifest this, are being concluded as we speak in the room where we're supposed to have this discussion. So without further ado, I don't think I mentioned my name. My name is Alex Wilma, again, with the Women's Initiatives for Gender Justice. And with me is Hazel Cameron, the head of the Human Rights Department at the UK FCDO office. Hazel, a few words from you for our opening address. Thank you.
Thank you, Alex, and thank you to you all for coming on Friday afternoon after a long week and at lunchtime. So I'm pleased we're able to offer you a little sustenance, at least. I'm really honoured to be with you here today and to have been able to support the holding of this side event. And I would like to express my thanks also to the Women's Initiatives for Gender Justice and to the Global Justice Centre for organising this event. Not only for organising this event, but for all the work which you have been doing on the Crimes Against Humanity Convention and making sure that it is both gender competent and survivor centred. Before going into the detail, I think it's worth pausing just for a second to acknowledge how far we have come collectively on the Crimes Against Humanity Convention. Just a few weeks ago in New York, the discussions concluded. Oh, yes, the discussions concluded by consensus, and this was not a given, to move towards diplomatic conferences in 2028 and 2029. This reflected the culmination of at least 2 years of work in the Sixth Committee. And these things take time, and people will say they take too much time. But of course, these are difficult issues. They're vitally important issues, and it takes time to get them right and ensure that the interests of all can be taken into account. So we're now another step closer to closing the accountability gap, to helping put an end to impunity for this particularly difficult to handle set of crimes. Almost 1 year ago to the day, I was hosting an event at the British Ambassador's residence in Brussels, and the event was a witness testimony event where 3 survivors of sexual violence committed by Russian forces in Ukraine spoke. And I don't think anyone who was there and listened to what those women had to say will ever forget it. And it's one of the reasons that I feel very personally committed to this work. The British government and the new British government under our Foreign Secretary David Lammy is committed to it. But I think it's something which, once you have heard those testimonies, you cannot help but be committed to as well. Just a couple of statistics, just to show the prevalence and the seriousness of the phenomenon of gender-based violence. According to the World Health Organization, 1 in 3 women will suffer physical and or sexual violence in their lifetime, and 70% of women in humanitarian contexts experience some form of violence. Last statistic, UN verified cases of conflict-related sexual violence increased by 50% in 2023 compared to the previous year. That is a massive increase in this day and age. I would like to just set out a couple of the points now which the UK has prioritised in the discussions thus far. On the hopefully new Crimes Against Humanity Convention. We have done various things to try to ensure a survivor-centred, gender-competent approach, in particular strengthening the preamble of the instrument to highlight the importance of a survivor-centred approach, incorporating into the Convention the Inhumane Act of Forced Marriage and amending the current definition of forced pregnancy. And lastly, calling for the strengthening of provisions covering the rights of victims and witnesses, including children. And this includes expanding the scope of victims to include children born of conflict-related sexual violence. And of course, this particular type of violence and this phenomenon comes with it shame and stigma, which passes down the generations. And we need to take account of the children who are affected by that, caused by events before they were even born. We have tried to make sure that our own positions are formulated, taking into account the views of victims and survivors, including at a Wilton Park event we hosted in March 2023, which some of you may have been able to attend. It will be a priority for us going forward that through the negotiation process, survivor engagement continues. The purpose of this is to make a little bit of a difference and have an impact, a tangible impact for survivors and for victims. Over the course of our conversation today, I'm looking forward to hearing from our expert panelists and all of you on your priorities and your proposals that we can take forward together. Thank you.
Thank you very much, Hazel, for really setting the tone and reminding us why we are discussing these issues and specifically gender justice within this convention. So let me then turn to you, Leda. You've been at the heart and center of these negotiations, these efforts before even the negotiations. Can you take us through what that looks like? Give for all of us a little bit an overview of what the process will look like from now and where we will go. Thank you.
Thank you so much. And really, thank you to the organizers and thank you to the UK. The Wilton Park meetings were held at a very critical time for the development of this treaty. And we could not have done it without the assistance of the United Kingdom government, who believed in it before it became real. And really, that's kind of the story of this treaty. I've been working on it for 16 years. My name is Layla Sadat. I'm a professor at Washington University and former special advisor on crimes against humanity for 10 years to the International Criminal Court. And crimes against humanity are really the most ubiquitous crimes that are charged in front of the ICC right now. And so while we have a vertical mechanism in place, what we needed was this gap, this horizontal mechanism that links states in sort of a sacred trust to prevent and punish these crimes. So for the past 16 years, first through a non-governmental process, if you like, groups of experts, we produced a model draft treaty in 2010. And then through a series of almost divine interventions and some good luck, it passed to the hands of the International Law Commission, where it was officially taken on as a United Nations project. But still, there was very little in the way of state support when the commission would come back every year to the Sixth Committee, a handful of governments, slowly increasing, but slowly starting, would comment. And so over the 6 years from 2013 to 2019, the International Law Commission developed what we now know as the 2019 draft articles on crimes against humanity. You can find them on the website. They will be the basis upon which the negotiation of the new treaty will take place. Now, once it got to the sixth committee, however, it was a very arduous process. I'm not sure if the time helped or hurt, but for 3 years, we really had a complete stall, in part because of the pandemic, in part because of the objections of some states, and honestly, in part because of the fact that every time you talk about this process, you sort of need to start all over again. And many states had not yet been socialized to the idea and needed more time for study. In 2022, there was a resolution that started a 2-year timeline to really discuss the text with a view to taking a decision this October. And thanks to extraordinary leadership, we actually managed to get a consensus resolution that was adopted by the United Nations Sixth Committee on November 22nd, after a very long day of back and forth negotiations with some sort of death-defying activity on the part of some delegations. And we watched them as one state called for suspension of the meeting, and everybody scattered to try to figure out what to do. But eventually, by the end of the day, the pieces were pulled back together, and we got a resolution that was just adopted by the General Assembly on December 4th, just this week. So what does this resolution say? It provides for a 4-year process, essentially. Now, for you guys, that seems like a long time. For me, it's like I've been doing this for 16 years. I'm literally 80% of the way there. So it's a 4-year process. This year will be a year for seminars, for webinars, for intersessional meetings, for proposals, such as the ones that we're going to talk about today. And then it kicks off in 2026 with a preparatory committee, with a working group that will take on board new proposals, and those will be eventually compiled into a document by a working group and a preparatory committee, and that will then be sent to the diplomatic conference. The preparatory committee meets a second time in 2027, and then there will be 2 3-week sessions in 2028 and 2029. So we can talk a little bit more about the process, but that's kind of the timeline. And the great news is we have a wonderful text to start with, which is the 2019 ILC draft. But in addition, this opportunity for new proposals to be taken on board as part of the working group and preparatory committee, which is where all of us come in. And thanks to our UK partners and other states, including Canada and Mexico and others, we were able to preserve at least some role for civil society, certainly for ECOSOC accredited organizations, with a possibility of additional civil society participation. And I thought I might just say one word, because in the description of this, they talked about what would it be, what do we mean by a feminist process or a feminine? And one of the things that is really striking about what's happened to get us here was the process that developed through the work, particularly of the Women's Initiative, Global Justice Center, led by Akila Radhakrishnan at the time, now by the amazing Elise Kepler. All these women's organizations came together to sort of put their shoulder to the wheel of a process that was stuck. And it was an inclusive process. It was really a women-led process. Many of the delegations that we worked with, including Mexico and other states, were led by powerful women, the EU representative at that time. It was a supportive process. It was a networking process. And what I really saw was it was a relationship building process where we really connected with individuals to talk about the proposals on the table, to talk about the draft treaty, and really try to push this forward. And I hope we can keep those, now that it's successful, I don't know if we'll be able to keep it this positive and constructive. It's not as if every state liked everything, but I do feel that there really was developed sort of a goodwill that happened through our shared commitment to stopping the commission of crimes against humanity. And you heard that in the applause that broke out in the Sixth Committee, and you heard that in the speeches of government. So I think the fact that this was a relationship building exercise, that it was inclusive, that it was as transparent as we could make it, given that it's led by states, is something really we have to hang on to as we build it into an even bigger global coalition. Let me just say 2 words about the specific topic, which was forced marriage. So one of the things that the International Law Commission started with, and one of the things our project started with, was this treaty could do no harm to the ICC. That was a key priority for ICC states parties. It was a key core commitment of our group and of the Commission. And so the theory was then, since we had the vertical relationship and we were expanding it to the horizontal relationship, it would make a nice package deal, right? We should take Article 7 of the Rome Statute as the text. And what started to happen is, as especially women's organizations and others started to look, but now we have a children's right group, we have slavery crimes, we have all kinds of others, environmental crimes, looking at this text and saying, you know, Article 7 was negotiated in 1998. It's now 2024. It'll be nearly 2030 by the time this treaty is adopted. Isn't it time that we make this a 21st century treaty? And what we heard in the Sixth Committee is slowly, even delegations that had been very committed to not touching Article 7, which is Article 2 in the ILC draft, started to say, you know, some improvements would be welcome. And one of them is this proposal for, oh, you missed me, my whole first part. Okay. And then the second thing, and this is forced marriage, is crystallization, right? What about things that have been developing through the work of the tribunals? And there's a wonderful paper that was really led, I think, by Patty, by Valerie Oosterveld, by others, proposing a definition that it be moved from the category of other inhumane acts into a separate crime. That's really a crystallization, right? That's the second C. It's developed through the jurisprudence of the Special Court for Sierra Leone and the ECCC and the ICC. And then we take that crystallized I'm on a spaceship. And we put it in the treaty. And then there are the new exciting developments that I know Akila and others will speak to, which is gender apartheid, which is a newly emerging norm. A new treaty can encompass all 3. And so I think I'll stop there. Thank you so much, Alix, and thank you, Hazel.
Thank you very much, Leila. And before I turn to the other speakers, may I ask, it was so helpful to hear indeed about how the process came about and what the process will be going forward for the people here in the room. Where can they find more information about all of these steps?
So our website at Washington University, if you just Google Crimes Against Humanity Initiative, you'll find everything. And the Global Justice Center has a dedicated site, Crimes Against Humanity Treaty Now. Yeah, and then Just Security has a whole series that they've been doing, and Asymmetrical Haircuts has some wonderful podcasts.
Good. Thank you very much. Many resources out there. And I particularly appreciate you indeed highlighting some of the feminist basic tenets that were incorporated in this process and that emerged from this process, and that we should very much keep in mind going forward. And maybe we'll discuss those going forward as well. So you mentioned one of 3 proposals already put forward for amendment in these draft articles. Gender apartheid is something that you mentioned already, and I would very much like to invite you, Akila, and perhaps if you would like to introduce yourself first, to take us through that. And then the second one that was mentioned already, indeed, is the slave trade. So Lily, indeed, if I can invite you to introduce yourself, and then after Akila discuss these proposals. Thank you. Over to you.
Thank you so much, Alix. Hi, everyone. I'm Akila Radhakrishnan. I'm an independent lawyer, and I'm also the strategic legal advisor for gender justice at the Atlantic Council Strategic Litigation Project. As it's been mentioned, there is a newly emerging concept of gender apartheid. And it's one that's really, I think it's important to start the conversation by not talking about the law, but the fact that this is about something that translates the calls and the lived realities of women, particularly in Afghanistan, into law. Because a lot of this started with their voices, not just in the last 3 years, but in the 1990s, right? There's a long call that Afghan women have been saying, this is how we recognize our experience. And when we talk about survivor-centered approaches, I think it's also important that we remember that it's not just about having survivors at the table to talk about their experiences, but actually perhaps respecting their agency and their own descriptions of what it is. And so on March 8th, 2003, there was actually a group of Afghan and Iranian women who came together to launch a campaign calling specifically for the codification and recognition of gender apartheid under domestic and international law. As this call came forward, it was dovetailing with work that Layla has started to describe, which was really going around as we were thinking about how do we start this conversation on gender and the Crimes Against Humanity Treaty early? How do we actually start putting forward ideas and proposals, not when women are usually invited to the table at the end, by actually centering it in the conversation in the beginning? And we're going to hear a lot more about what those efforts were contained from others. And so where we began was, we were looking at and saying, this really important concept, I think a lot of people recognize its rhetorical value, but, we did want to look at and interrogate, can we make this legal argument, right? Because in order to put forward a proposal on how this could be defined, what it means, we did need to interrogate those questions. And so there was a group of, we did many consultations, but there were a group of experts. We really looked at several things that I'm going to just briefly describe. So we started by looking carefully at the parallels between how apartheid was implemented in Southern Africa and the current system in Afghanistan. And we saw how the Taliban's ever deepening and institutionalized oppression and domination of Afghan women, girls, and LGBTQI plus individuals evokes the dystopian ambition of the South African apartheid government. We also looked at and saw parallels in how both South Africa and under the Taliban Afghanistan, members of the oppressed group were and are deliberately and thoroughly cut off from opportunities that could provide a path to advancement and autonomy through the denial of access to work, equal education, equal health care, justice, political power, civil liberties, and freedom of movement. What we really saw was that the regimes aimed to maintain dominance and entrench systems of governance that eviscerate self-control and any possibility of full personhood and advancement. We also looked at what is unique about apartheid, how its intent and animating context distinguish it from other international crimes, including gender persecution. So apartheid requires the commission of an inhuman act of requisite character with the intent to maintain an institutionalized regime of systematic oppression and domination. It's a crime of sweeping dystopian vision, and through its commission, its perpetrators seek to maintain a form of governance designed to systematically oppress and dominate a subset of society so that the dominant group may live alongside them and benefit from their subjugation. It is a regime which, by design, self-perpetuates under perpetrators' control from political, economic, and social life to such a degree that with the remnants of their own resources and freedoms, they cannot organize to escape or overcome their orchestrated subjugation. The implicit justification for creating and calcifying such a system is the perceived superiority of one group over inferior groups, fermenting just under the surface of an apartheid regime's belief of a group's less than human status are bigotries that are deeply rooted in many human societies, but radicalized and institutionalized in the cultivating environment of an apartheid regime. So I know I'm going a little long, so I can see Alik's our moderator, so I'm going to cut through a little bit. But I do want to say that the other piece of it is that the crime requires the commission of an inhuman act with the intent to maintain that regime. So perpetrators of apartheid also have a fundamentally discrete intent. They do not only aim at the deprivation of rights, severe or otherwise, by reason of the identity of a group. Rather, perpetrators of apartheid intend to maintain a system of governance founded upon the systematic domination and oppression of another group or groups to which the perpetrators have accorded inherently lesser value. The intent to maintain an institutionalized regime of systematic oppression and domination of one group or another is markedly different in scope and substance from the crime of persecution, though no less serious. This remains true even where many of the means through which an apartheid regime is propagated, which is to say that the deprivation of fundamental rights of a targeted group, share the same factual basis that are relevant to the crime of apartheid. So while interrelated, the crimes are in fact distinct. In addition, the coexistence of the crimes of apartheid and persecution is already recognized in the existing international legal framework. For example, race-based apartheid and the crime of persecution on the grounds of race are both codified in the Rome Statute as replicated in the draft Crimes Against Humanity Treaty. And finally, the codification of gender apartheid would allow victims and survivors to hold the perpetrator regime and or the individual perpetrators responsible for the totality of their conduct. The rationale also underpins ICL's practice of cumulative charging and recognizing the complete picture of criminality for which an accused must be held to account. So I'll stop there, but I will note that thus far in the discussions, we've actually seen 11 states support and say that they're considering supporting the codification of gender apartheid in the treaty. So we're really delighted to see that this work that we have done in putting these legal arguments forward has started to take traction in this process already. Thank you. Sorry for going long.
Not at all. And thank you so very much, Akila. That was crystal clear. To me, and I saw a lot of heads nodding around the room as well. Before Lily, I ask you to take the floor, we're going to take a 5-minute break because we not self-solving problems are my favorite problems. Our tech is fine. We don't need a break. However, I wanted to say, if you want to use that to go outside and get some more food or walk up here and get something to drink, please do not hesitate to do so. So, well, then, without further ado, Lily, over to you. If I may please ask you to introduce yourself and guide us a little bit through the slave trade in connection to this convention. Thank you.
Thank you so much, Alix. Hello, everyone. Thank you so much for the organizers for convening and putting a lot of labor into this discussion, which I think it's increasingly important to merge The Hague and New York, and more importantly, other worlds and locations that have a stake in the treaty that's going ahead now. So congratulations to Leila, Akila, everyone involved for your leadership. And before I start, I have to really thank Patricia Visser-Sellis, your work and legacy, without which we wouldn't be talking about a proposed enumeration of the slave trade, and whose work I've been honored alongside Professor Jocelyn Gettin-Kassenbaum to support over the next years. And if we talk about feminist justice, we have to talk about feminist collaboration and really intergenerational and transgenerational mentoring, which I have the honor to receive and will make sure to give along as well as the years progressed. Maybe to situate the international crime of the slave trade as a feminist concern in the context of international law, and it may not be one very obviously, but I think it's a crime of feminist concern because it often drives, but also provides the context for severe forms and various forms of gender-based crimes, including sexual crimes, to occur. And it's often also the precursor that makes persons of all ages and genders end up in situations in which they experience various forms of gender-based crimes. To illustrate factual examples across situation, countries and locations include notably the Yazidi ethnic and religious minority in locations such as northern Iraq and Syria, migrants of African descent across the routes in Libya, now increasingly also in Sudan, for a long time already South Sudan, as well as Tigrayan and other ethnic minorities in northern Ethiopia. And legally, as per the 1926 and 56 convention, the slave trade is really the intent to reduce a person into slavery, maintain them in a situation of slavery, or dispose them out of a situation of slavery. And to concretize this further, it prohibits all acts that are involved in the capture, in the acquisition, or as mentioned, in the disposal of a person, and notably in the process of reducing them into situations of slavery. And by comparison, slavery or enslavement prohibits the exercise of any or all powers attaching to the rights of ownership. I always have to read that one to not miss one part of the sentence. And that is really an invitation to also congratulate the Office of the Prosecutor for Monday's launch of the first ever policy on slavery crimes that, in particular, among other various guidance, provides insights into how to prove the exercise of any or all powers of ownership over a person across various contexts, and also from an intersectional and survivor-centered perspective. You may ask, how do we understand or prove the crime of the slave trade? So to clarify, and also in relation to enslavement, the slave trade is not dependent whether the actual enslavement occurs. So for example, if we look at the Libya context, for example, the person that is slave trading one person, either from being a free person into a situation of enslavement or from one situation into another one, it's irrelevant or immaterial for establishing the legal characterization of the slave trade, whether the subsequent enslavement occurs. And equally, consent and coercive circumstances are not required to prove in the context of the slave trade. And if we look at from the ICC across also to the domestic cases already and international investigations ongoing, I already mentioned some situations. But if we look at the cases of Katanga and Katanga, Ongwen, and more recently Kony, we find acts of the slave trade in those cases, and under the domestic level, under the principle of universal jurisdiction as well as active personality principle, we increasingly find indictments, arrest warrants, but also jurisprudence in some of the contexts that I mentioned that also deal with the slave trade. And whereas several states, and among them are the Netherlands, Norway, or Liechtenstein, for example, have the slave trade as standalone crimes in their domestic criminal code, the slave trade is absent, unfortunately, as an underlying act of crimes against humanity or war crimes in international and non-international armed conflict. And at the same time, and despite customary international humanitarian law 94, which prohibits the slave trade and slavery in all their forms, slavery is also not outlawed as an underlying act of war crimes in either armed conflicts. 1 minute? Okay, cool. And just to procedurally locate and also maybe distinguish, there are various proposals, but I think the multilateral response to these proposals, I would say, are different but complementary, as much as the feminist efforts to advance these proposals are complementary as well. So on 11 of April 2023, it's Friday, the permanent mission of the Republic of Sierra Leone to the United Nations submitted in writing a proposal to indeed include the slave trade as an enumerated provision in the draft articles. And in the resumed session the following October, the African group voices expressed support for the provision in the draft articles. At the same time, a little bit earlier that year, in July, at the EU's SALIC summit, one of the points raised in the concluding declaration of the summit was that EU and SALIC states recognize slavery and the slave trade to constitute crimes against humanity. And from these developments, we can derive an understanding that there's increasing but also cross-regional support for the proposed addition to the draft articles. And in parallel, and notably, I already mentioned briefly the gaps in the Rome Statute. In the first quarter of 2024, the Republic of Sierra Leone also sent a communication to the United Nations Secretary General in accordance with Article 21.1 of the Rome Statute and proposed amendments to Article 7 and 8 of the Rome Statute. And also in April 2024, Sierra Leone launched the Group of Friends on Slavery and the Slave Trade Crimes. And from a multilateral perspective, this Group of Friends does not only look at the draft articles, but also at the proposed amendments to the Rome Statute, and will really be kind of the fertilization ground for both these proposals to advance over time. The Group of Friends is one that's also cross-regional, and that really also wants to include perspective, including from Caribbean countries, as well as other countries of the global majority, since this is really a concern of the global majority that is being advanced on the multilateral stage right now. And 30 seconds, if I allow to close. So I already mentioned that the slave trade is a crime of feminist concern, but I also think it's a demonstration that conduct and crimes that have long been a concern of the global majority now have the possibility to be advanced. And it really is also a testament to the fact that the draft articles is an invitation and possibility for reconsidering who makes international law, where it is being made, and what concerns can be put forward that maybe historically and even presently haven't been able to have the center stage in that way. So thank you so much.
Thank you. Thank you very much, Lily. I hear a lot of hope and a lot of further ground indeed for, future work on these issues. Leila, would you like to come in for a moment? Thank you.
Maybe just one thought. What you can hear in both Akila's and Lily's presentation and what I alluded to, and you already heard, the UK supports forced marriage. There will be different constellations of states that will be supporting different proposals. One of the things that was very exciting about the slave trade proposal wasn't just that we filled a big gap, right, in international law, which is huge, but it really galvanized, it brought the interest of the treaty to the attention of global South states who had previously been slightly skeptical that this was like Nuremberg 2.0, which they're not really so interested in, and didn't want to see this as something imposed upon them. And I think to Lily's point, the agency that the slave trade proposal gave to global South states led by Sierra Leone, but also Gambia, Nigeria, many other states, was very different. Some of the gender proposals, conversely, will not be so appreciated by that same constellation of states. That will need a different constellation of states who will see those as very important to their constituencies or to their identities. And so I think we will see different constellations grouping around these different norms. Forced marriage is going to be a little harder, I think, than slave trade, but because we do have this jurisprudence, it's really a question of political will and technical drafting, right? There is a definition proposed. Gender apartheid will obviously be the heaviest lift because it's the newest crime. But I just kind of wanted to add that as we're thinking about the intersection of the gender issues, global South issues, and the other crimes.
Thank you very much, Leila, which will very much inform also our collective or individual involvement. So again, if colleagues, friends here in the room and beyond seek to have a bit more information about this and seek to follow the process, or those the two websites as well, please, Elise. Noted. Thank you. Thank you very much. Then before I move on to you, Ashida, Akila and Lily, you both mentioned a number of points, particularly lived reality and then intersectionality. Lived reality, Uliana, will ask you to comment on that, but Lily, might I come back after Ashida and Uliana's comments to ask you to maybe break down a little bit the concept of intersectionality, to understand better how this applies as an emergent concept, but more going beyond that term, so that we all in this space can sort of understand where the thinking is going. Thank you. But first, and I'm very happy to have Ashida here with us. Ashida, if I may please ask you to introduce yourself and then talk us through one of the very crucial concepts in international criminal law that will seek to not codify, but look at reproductive violence. Thank you very much, Ashida.
Thanks, Elix. I'm Ashita. I'm the legal advisor at the Global Justice Center. And before I begin, I just want to say what an honor it is for me to be speaking on this panel alongside everyone I've sort of looked up to for years now. Also, yeah, jumping into it, but before I begin discussing sort of the specific amendments or the specific proposals to advance protection for reproductive autonomy within the draft articles or the future convention, I want to begin by defining what we mean by reproductive violence, just to set some context. So essentially, reproductive violence refers to violence that interferes with reproductive autonomy and rights, or violence that's directed at people because of their actual or perceived reproductive capacity. And now, this is not just like an abstract category. It is something very real that happens. So examples of this include forced pregnancies, like we saw in the Ongwen decision in Uganda. It also includes forced contraception and forced abortion. An example of that is in Colombia, female fighters within the FARC, for instance, were subjected to forced contraception. Essentially pregnancy was considered incompatible with their role as fighters. And so forced contraception measures in the form of hormonal contraceptives, injections, implants, etc., were imposed to standardize their bodies for war. And in the event pregnancy did occur, they were subjected to forced abortion, again, so that their bodies could remain ready to continue fighting. There are other examples like enforced sterilization, forced breastfeeding on one side, and the flip side, denial of breastfeeding. All of these sort of help put this into context that it's a really real thing that happens. It's not an abstract sort of academic category of violence that we need to look at. Consequences of reproductive violence are not only severe, but can be lifelong and profound. For instance, it has the ability to create and destroy kinship relationships. Very sort of permanent impact, lifelong impact is what it can have. However, despite the severe and profound impact it can have, currently only two explicit categories of reproductive violence have been codified under the Rome Statute, and then as a result, under the draft articles which borrow from the Rome Statute. And these are forced pregnancy and enforced sterilization. And the ICC, in its Ongwen decision, sort of, while going into the jurisprudence of this, identified that the actual value underlying these two crimes and the actual value that the codification of these two crimes protects is reproductive autonomy. Now, obviously, reproductive autonomy can be attacked by conduct that may go beyond or may not meet the definitions of forced pregnancy and enforced sterilization. And so at the moment, within the legal framework we're left with two options. If reproductive autonomy is violated or attacked with conduct that may not fit the definition of forced pregnancy or enforced sterilization, we have to somehow shoehorn it into either sexual violence or other inhumane acts. Now, neither of these is an ideal solution. Why do I say it's not ideal to club it with sexual violence? Because I think the conflation can lead to certain problematic results. Of course, reproductive violence can sometimes happen alongside sexual violence as a consequence of sexual violence. Think of pregnancy resulting from rape. But reproductive violence can happen on its own. It is an independent category. It may often not involve any sexual component. Some instances of forced contraception, for instance. And in those cases, it's difficult to fit that category within sexual violence. There's also, we can try fitting it under other inhuman acts, but that sort of brings with it the risk of lacking the specificity that may leave out the specific harm of reproductive violence, which is denial of reproductive autonomy. It may also miss out on recording specific reproductive consequences that the victim has suffered. And so the proposal is to explicitly include reproductive violence within the draft articles. And the specific amendment for this would be in draft Article 2, which includes the list of crimes. And so 2.1g, for instance, includes rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence. And the proposal is to amend this to read or any other form of sexual or reproductive violence. Now, what does this achieve? Why do we want to do this? Of course, like I said, there's conduct beyond forced pregnancy and enforced sterilization that this will help capture. But there's also three key reasons why this will sort of help advance justice. First, there is sort of a normative argument behind this. There is discursive value in the law explicitly referencing to reproductive violence, calling it out explicitly signals to victims, perpetrators, society, the condemnation of international community for conduct that may amount to reproductive violence. It gives victims language to be able to express the harms and consequences of reproductive violence that they've suffered. There's also practical utility behind this. Explicit sort of recognition of it directs attention of investigators, documenters, prosecutors, judges to these harms, leading to not just better documentation, but then consequently better justice and accountability for these harms. And we've seen that with the feminist movement that's fought so hard for sexual violence to be recognized. And then third, sort of referring to it explicitly, will reduce within criminal law time spent on preliminary questions such as litigating whether certain conduct is even criminalized or not. And it goes back to the legality principle within criminal law that, you have to, with sufficient specificity, the perpetrator should be able to anticipate that their conduct would have been criminal. And so by explicitly referring to it, we sort of avoid wasting resources, times, taking victims through these lengthy processes of like technical procedural hearings just to establish that the conduct is actually criminalized. So that's sort of the first big proposal, and I'll quickly just talk about the two, and then maybe we can deep dive into if people are interested in the questions. The second one relates to including more inclusive language within the treaty, specifically within the definition of forced pregnancy currently, because the definition only refers to woman, and the proposal is for it to include woman, girl, or any other person. This is only to sort of reflect the reality that it's not just women who can become pregnant, but girls, trans men, non-binary, and intersex people can all, in certain cases, become pregnant, and the law should just reflect that reality. And then very quickly, the last proposal is so the draft articles, like the Rome Statute, within the definition of forced pregnancy, refer to this curiously worded sentence, and which just says that the definition shall not in any way be interpreted as affecting national laws relating to pregnancy. And we sort of briefly touched upon this yesterday in the Crimes Against Humanity workshop as well, that this sentence is essentially superfluous. It has no legal effect. Ong Wen recognized that as well. And so if it has no legal effect and it's superfluous, it can risk causing confusion. So it's just better off being deleted. And as we move forward 25 years from when this was actually included, we're better off going forward without this sentence. And yeah, that concludes the three proposals. Yeah.
That's perfect. Thank you so very much, Ashita. Crystal clear, and your call and encouragement as well. You really touched upon the necessity to encapsulate, use the right words to reflect lived experience. That is at the heart, I think, of what you shared. So building on that, Uliana, if I may next turn to you, one of those lived experience, or perhaps we can call it victim focused, or perhaps we can call it survivor centered. There are so many of these words and aspirations that we have. So, Uliana, if I may ask you, well, first indeed to introduce yourself, please, and take us through what that means to you. What terminology you employ, how these issues can integrate a legal treaty, and what could states and us as a collective do to achieve that. Thank you very much.
Thank you, Alex. And thanks to the sponsors of this event, partners, for creating this space to discuss the importance of advancing gender justice under the Crimes Against Humanity Treaty. It's an honor to share insights from our work, drawn from our work in Ukraine, alongside such distinguished panelists. My name is Uliana Poltavets. I represent Physicians for Human Rights, working in Ukraine. Physicians for Human Rights works at the intersection of science, medicine, law, forensics, and public health to document violations of human rights and support justice for victims of these violations. As someone who works directly on documenting attacks on health, torture, conflict-related sexual violence, through the experience of healthcare workers, I want to highlight why a victim-centered approach isn't just an abstract principle. It's a critical and practical necessity for justice and healing. For survivors in Ukraine and in conflicts worldwide, the Crimes Against Humanity Treaty represents hope for recognition, accountability, and tangible support. Ukraine's experience during the Russian full-scale invasion, but also prior to that, illustrates how widespread and systematic and targeted atrocities can devastate civilian populations in communities across the country. In just over 2 years, 326 cases of conflict-related sexual violence have been recorded by the Office of the Prosecutor General, with survivors including women, men, and children. Our Ukrainian partners, human rights organizations, ZMINA and Media Initiative for Human Rights, have documented patterns of torture, sexual violence, and inhumane treatment in detention conditions in occupied territories. These crimes were not isolated acts. They were part of calculated state policy designed to terrorize, subjugate, and destroy communities, and as such should be investigated as crimes against humanity. For many of the survivors that we talk to and our partners talk to, these acts are compounded by secondary harm. The lack of accountability mechanisms in occupied areas, the challenges of navigating domestic justice systems, and the societal stigma that often accompanies sexual violence. The Crimes Against Humanity Treaty, with its focus on state obligations, offers an opportunity to address these gaps and reaffirm survivors' rights on a global stage. Our partners tell us that the most common phrase among survivors is, "We want the world to know about what happened." And this really underscores how these crimes are relevant for the whole humanity. The victim-centered approach is grounded in the lived realities of survivors. In Ukraine and in other contexts, survivors of sexual violence make it known what they need most: safety, acknowledgement of their harm, a support system, and access to justice and reparations without fear and re-traumatization. This approach recognizes survivors as rights holders, not just passive participants in the justice process. It means that victims and survivors must have agency and respect. Survivors should make informed decisions about their participation in the justice process. Trauma-informed care, confidentiality, culturally sensitive support are non-negotiable. They should have access to holistic support. Justice must go beyond trials. Survivors need access to healthcare, such as emergency contraception, abortion services, and mental health care, alongside housing, education, economic opportunities that are necessary to rebuild their lives. Accountability and prevention are crucial. A treaty that clearly defines crimes against humanity, including sexual violence, sends a message to states and perpetrators. These crimes will not go unpunished. It also helps to ensure that national legal systems incorporate international standards, which is critical for awareness and enforcement. In Ukraine, the legal framework for addressing sexual violence as a crime against humanity has just been strengthened. We have just ratified the Rome Statute, and incorporation of the criminal code of these articles into the criminal code has already started. This treaty offers a chance to overcome a key challenge in ensuring accountability: the lack of harmonized national frameworks to address crimes against humanity. It also helps to strengthen the norm and support existing and future investigations. It is an important pillar of awareness raising and engagement of stakeholders in the justice systems and in support systems along the survivor pathway, including clinicians, because it is very difficult to collect evidence and document something for a crime that you don't know or are not aware that it exists. A survivor-centered approach also means that protecting survivors from re-traumatization, guaranteeing their safe participation in the justice process, as the treaty ensures that the state starts prompt, thorough, and impartial investigation. Medical legal documentation plays a crucial role here. Rigorous trauma-informed documentation of sexual violence is critical not only for prosecuting crimes, but also for uncovering patterns of abuse and aiding survivors in their pursuit of justice and reparations. Medical legal evaluations can provide vital evidence linking perpetrators to crimes and establishing the widespread and systematic nature of these crimes. The treaty should strengthen state obligations to ensure the availability of such documentation conducted in line with international standards and survivor-centered principles. But the treaty must do so much more than set out the obligations. It should also operationalize a survivor-centered approach. This means requiring states to guarantee physical and mental health support to survivors, ensure accessible justice, physical mental health support system for survivors, expand reparations mechanisms to recognize the diverse needs of victims. One case that informs our work at PHR is Kavumu trial in Democratic Republic of Congo, where a sitting lawmaker and others were convicted for crimes against humanity for systematic rape of young girls. That case succeeded because it centered survivors at every step. Their safety, dignity, and voices were prioritized. Ukraine can and should learn from this example. In Ukraine, interim reparations for conflict-related sexual violence survivors are a promising step forward. More than 300 Ukrainians have already received payments from such reparations. Over 500 applications have been received, with men constituting the majority, most likely due to practices in Russian detention. This really highlights the a larger scale than that is seen in the law enforcement system. However, these efforts must be scaled up. To conclude, the adoption of Crimes Against Humanity Treaty is a vital step toward atrocity prevention, justice, and reparations. For survivors of sexual violence in Ukraine, it offers a hope that their suffering will not be ignored and their rights will be upheld. During negotiations and developing positions, governments should engage victims in consultations and strive to elevate their voices. Victims should also be consulted for the definition of what it means to be a victim, to strengthen the definition. The treaty is more than a legal document. It is a promise to survivors and families of victims everywhere that they're seen, heard, and supported. We must advocate for a treaty that lives up to this promise. Thank you.
Thank you so very much, Juliana. Indeed, the treaty is not a legal document; it is a promise. We've yes, indeed. We'll use that. We've discussed quite a bit the momentum that has been ongoing and advocating for gender within this convention, being survivor-centric, victim-centric, but also to have an intersectional approach. So what I may ask you, Lily, perhaps to take us just in a few minutes, what does that actually mean to have an intersectional approach? To some of us, it means, I know, like looking at the structures of violence that can underpin or instigate any form of violence indeed, but please to inform us all and maybe, thank you.
Yeah, so less a lecture, maybe more a provocation of thoughts that hopefully can trickle down into your practice and work. So intersectionality, as you may know, is a term coined by Kimberly Crenshaw, who's a lawyer and scholar of African descent, living and working from the United States. And her work underlined that discrimination, oppression, and violence against women of African descent in the United States have been and are rooted in structural hierarchies that are manifesting in particular ways in the United States, but that are also global hierarchies, and that such a discrimination occurs on grounds of race, gender, and class. And notably that we have to move from a single axis framework to a multi-axis framework to understand discrimination, oppression, and violence that occurs on multiple grounds and not just one. And that really the single axis understanding of violence is really one through a wide lens, wide not necessarily only in terms of race, but also social construct and worldview and domination. But more critically, and before the term was coined, it's really a concept and understanding that emerged from the struggles of communities of the global majority and their fight for equitable lives, but also their fight against global hierarchies. To name a few, is colonialism and ongoing coloniality, racism, sexism, homophobia, ableism, ongoing violence and oppression against indigenous people, among others. I think if we move this to the fear of international crimes, is, as you mentioned, Alix, it's important that the crimes we are looking at don't occur in a vacuum, that they are driven by systems of structural domination, system of structural discrimination and oppression. And they are also a determinant factor in the impact of international crimes on persons, depending of who they are and who they represent in the context and societies in which they live. From an international criminal investigative perspective, I think it's also important to note that an intersectional approach delivers you a more expansive crime-based linkage evidence, contextual evidence, and also impact evidence to really understand what has happened by whom and why. And given that the draft articles doesn't just talk about punishment, but also prevention, if we really want to prevent, we have to look at the root causes as to why these atrocity crimes occur. And there we really have to look at what are the context-specific manifestation of structural oppression, what are the laws, what are the policies, who is in power and why are there no evidence of equitable lives in a given context, that at any moment when a conflict breaks out or other forms of structural mass violence occur, if we have a patriarchal society, it is queer lives and the women and the lives of women and girls that is at stake. If we have a racialized society, it's persons that are racialized in that context that are being most targeted. And of course, if we also speak of protection and reparation and any kind of form of justice responses, these need to have an anti-discriminatory understanding and also an anti-colonial understanding, so that white savior lenses and white understanding of what justice responses should be are not furthered at the cost of those concerned.
Fantastic. Thank you so very much, Lily, for taking us through this. May I now turn to you, Hannah, please? Indeed, again, to ask you to introduce yourself, but also to take us through, based on all that we have heard so far this week, but also in this room, what considerations should we, both civil society, academics, states, keep in mind in advancing gender justice in this path forward? Thank you very much, Hannah.
Thank you so much, Alix. And I just want to say a big thanks for the invitation to join this panel today. So my name is Hannah Gary, and I am at UCLA Law School. I was pleased to hear, Lily quoting the remarkable scholarship of one of my colleagues at UCLA, Kimberly Crenshaw, and the innovative work, cutting edge work that she has been doing. I am the executive director of the Promise Institute for Human Rights, and we are an institute that focuses on being a leader in education and impact and scholarship in human rights out in California. My background is I started out in international criminal law, practicing at the Yugoslav and Rwandan tribunals in the appeals chamber, and then in the presidency. And then subsequent to that in the Cambodia tribunal. So I've spent about 5 years working on crimes against humanity jurisprudence, which has piqued my interest in joining Layla. And thank you so much, Layla, for the invitation to join the civil society network that built up around the draft articles and the sixth committee process. And I'm a relative newcomer, but I'm really grateful to be part of all of this. So what I'm going to say about states and CSOs is really just a summary and a reflection of what I've been learning from all of you in the last year or so. And starting with states, what I've been hearing time and again is that as we move forward, we would encourage states to really think about allowing for broader access for CSOs as much as possible in the negotiation process, particularly those that are survivor-led, grassroots, and if possible beyond ECOSOC members, to include other groups, again, that are survivor-led, with that access being clearer and streamlined, especially as early as the working group stage in this next year, as much as possible. And second, that states could think about having broader participation in their delegations, particularly inviting perhaps members of survivor-led grassroots CSOs to be part of those delegations where possible. Third, delegation membership could also and should also involve and be gender diverse and inclusive with diplomats, women, leadership, all genders leadership who are consulted throughout and who are leading in the process. And fourth, of course, we all urge all states to champion and propose the proposed text that advances gender justice, as you've heard today, as broadly as possible. And one thing that I heard from the Asian Justice Coalition yesterday is for those global South states that are champion of some of these gender justice proposals to, like Mexico did leading up to negotiations, to consider hosting other states cross-regionally and championing those proposals to bring in states that have perhaps felt on the margins thus far with regard to the whole process. And then finally, another encouragement for states is putting resources behind all of these processes in order to really involve and be led by survivor-centric organizations and voices. This requires resources, lots of resources. With regard to civil society, so we've got this next year of 2025 with the working group process. It's really an opportunity for CSOs to form core groups and networks around the various proposals, for refining those proposals and texts for states and putting them forward that advance gender justice, including those that are for fixing gaps or mistakes in the Rome Statute, those that are also pushing forward progressive development of the law, and to work together to find and to work together with friendly states championing specific proposals by the deadline for formally tabling, which I understand is in April of 2026. And as Layla mentioned, there's a lot of opportunity for broad engagement with a bigger table, as Akila mentioned yesterday, through seminars and webinars and trying to be as inclusive as possible in the process. Second, because we have this longer timeline moving forward of 5 years for the negotiations, one thing I've been thinking about is moving forward soft law instruments for development of new norms and alongside the codification effort here through the Draft Crimes Against Humanity Treaty process. I got involved specifically. I was really fascinated by what's happening here because of the invitation to join the End Gender Apartheid campaign. And, I'm thinking now about how we might get states on board through, soft law processes such as drafting a declaration or perhaps trying to push through a UN Human Rights Council resolution that might also, recognize gender apartheid. So that's another consideration for civil society for these new norms and progressive development. A third recommendation to CSOs, it has to do with process. And here and now, I'm just reflecting back what Akila and Lily have been sharing with us about the importance of gender justice feminist process throughout the negotiations that is comprehensively inclusive and intersectional in the work over the next 5 years. Not just a focus on the content of the treaty language as incorporating gender justice. And you really use this as an opportunity for platforming women, all genders, impacted communities in leading, having agency in all stages of the process, and keeping them updated and responsive to their wishes, their voices, and building the network, again, with resources to build that bigger table. A fourth recommendation is one that came to mind for me yesterday as I was hearing about feminist process, one that I'm not that well versed in understanding is perhaps, the Women's Initiatives for Gender Justice could move forward with a brief on the process and lessons learned from the Women's Caucus around the Rome Statute, with practical recommendations for how to implement, such as mapping of impacted marginalized communities across geographies, for having them leading and listening to them and their voices, keeping them informed of process. And this requires the practicalities of translation of all materials into multiple languages, drafts, proposals, etc., making them as accessible as possible. And then finally, Akila encouraged us yesterday not to be cowed by fear-mongering and by asking for too much, and to be bold in moving forward with what we actually need for gender justice. Layla noted that crimes against humanity all along has played the role throughout the 20th and now 21st centuries of addressing new harms and filling the gaps. And here we are in the 21st century in a time of crisis and inflection. And it's time to think about fixing and updating the Rome Statute and addressing and moving forward codification of existing norms and also crystallization of emerging, such as environmental proposals, and creation of new, such as the gender apartheid proposal. So with that, I will close. Thank you.
Thank you very much. Thank you very much, Hannah. It was very rich indeed. Yes. Thank you. On the point, may I reflect very quickly on the advocacy movement, civil society involvement, similar to the Women's Caucus, indeed, at the Rome Statute, that led to the creation of this treaty that we're, that brings us together really at this ASP. Your encouragement are indeed very well heard. I wanted to ask, perhaps, but sorry. No, I'm not going to question just yet. Thank you. But what I was going to say that perhaps I'll ask my panelists during the Q&A round to reflect a little bit on this solidarity, on this advocacy movement with these feminist principles in mind, but I'm also looking at the time. So before I turn to the Q&A session, I would like to turn back to Rashida, please, and ask you to discuss a gender audit of this convention. Thank you.
Thanks. Yeah, so a gender audit essentially refers to a gender analysis of the draft articles as they exist today. And I often reflect within myself, and I've had conversations with people in this room, if audit is the right word. It gives you this sense of like, I can input some formula in an Excel sheet and we have gender equality. That's not how it's going to work. That's how it's never worked. And so like I reflect on using the term myself, but essentially a gender analysis of the draft articles as they exist today, because we have a seat on the table in the drafting process. Unlike a lot of times when feminists have had to unfortunately come in post the fact and push for sort of progressive interpretations of texts that may not have been ideal because no one listened to them when the text was being negotiated. The idea is that let's try and push for the most progressive text we can in this treaty to give ourselves the tool to push for a gender competent, intersectional, survivor centric sort of draft articles and a final treaty. And the proposals that all of us have been speaking about here are sort of a part of it, a part of sort of making the treaty more gender progressive. And these proposals, are ones which will make you think of gender in the first blush, like forced marriage, reproductive violence, gender apartheid. One will think of gender immediately when these words come up. But the treaty has other provisions which are, quote unquote, neutral. And feminists have always said that neutral has always equal to patriarchal, that neutral provisions are ways for existing structures of oppression to like find pockets to come up and continue to oppress. So neutral provisions are not really neutral. They are tools in hands of patriarchy, colonialism, racism to continue empowering themselves. So the idea is to look at all provisions, those that we think are neutral, jurisdiction, prevent and punish, fair treatment of an offender, and see what the gendered impact of this will be in practice, and then recommend textual changes if it's relevant, but also not for all. It's counterproductive to be like, yeah, let's just add the word gender in all articles, and it's great. But it could be counterproductive. Often what we want is for interpretation for text to be gender progressive. And so a gender analysis would involve both, I think, textual amendments, interpretative guidance, learning from lessons in the past from the Women's Caucus, sort of, we all stand on shoulders of feminists before us and build upon it. And then, yeah, I think this sounds like too much. It could be sounding like too much, but I think we owe it to ourselves and feminists before us to ask for everything we want to. There is no asking for too much, I think, from a feminist perspective, because what we don't ask for is then upholding patriarchy, is then upholding colonial structures, racist structures. So I think as feminists, our job is to ask for everything we think will move us towards a gender just world And we learn from processes before us. We learn from what the Women's Caucus did. Of course, think about who was missed out, what voices were missing, how do we bring them in. The briefs themselves were a process of trying to bring in multiple voices to sort of draft these proposals, not to say that it's perfect. There's obviously more voices to bring in. And I think Leila Akila Lili will speak more to this, but we'll, I think, still miss out. But the idea is to try and bring as many voices on the table, including sort of survivors and victims' voices who are not a unified category in themselves. So we always think we can like add and stir these categories, but that's not how it functions. So we at least owe it to ourselves to understand populations of concern that must have a voice in this, and that those populations within themselves are not unified. You can't just have one person be like, yeah, this is representation of this voice. And we owe it to ourselves to like do better than those in the past, and those in the future will try and do better than us. And it's about building on momentum from the past.
Thank you, Ashita, very much.
We do owe it to ourselves. Indeed, and that's me testing the microphone, because let's turn indeed to a Q&A session. Looking at the clock, I have room for about 2 questions and comments. So I see Sharon, and I believe you wish to intervene as well. So I'll take these 2 and then turn back to the panelists for their responses. Thank you.
Thank you very much. My name is Sarah Kasanda. I work for the ICT and I appreciate the panel and the efforts towards making this treaty gender competent. My comment is in relation to reproductive violence, and this is one of the crimes that really requires an inclusive approach to defining these crimes. We've spoken about forced pregnancy, we've spoken about forced marriage, but there are 2 components that are left out in my view: the forced motherhood component and the circumstances of birth. And here, several times when has been cited, but just to highlight an example. When these women who were abducted were forced to give birth, often it was in very difficult circumstances, using grass to cut the umbilical cord, no obstetric care of whatsoever, so chances of survival were very slim. That in itself is terrible harm. But even after that, when they had these children in the camps, they were compelled to make sure that these children did not cry, these children did not disrupt, but also it hampered their ability to escape because you have children. And so what I'm basically saying is, as we define these crimes, we need to consider diverse experiences, taking into account how they could manifest so that we get the complete criminalization of the harm. Thank you.
Thank you. Gosh, thank you very much. And I certainly didn't mean to cut in line. And I don't have a question, but more of a comment or maybe a little bit of context. And my name is Jim Johnson. I'm the prosecutor for the Residual Special Court for Sierra Leone. And maybe just a reflection is the best way to put this. But I can remember back in 2003 when we were very much grappling with this phenomenon of the bushwife. And how do we fully reflect this phenomenon in our charging instruments? It was not sexual slavery, it was something more than sexual slavery. It had so many different elements that weren't part of the traditional crimes against delineated crimes and the crimes against humanity. And a young Ghanaian attorney named Adjoa Wayafi wrote a little memo and circulated this memo and this concept of forced marriage. And, that we took it, we ran with it, and it is thanks to so many of you in this room, it has grown into where we are today. And so really just to add a little context to where forced marriage came from and where that thought came from, and to thank all of you for taking this notion that started as an idea in our conference room around the table and grew into something very much more. And so I just want to thank you all for that.
Well, thank you. Thank you very much for that acknowledgement. Sometimes it starts with a little memo. I think that that's something that we can all take home with us. Let me now turn to our panelists to see if anyone would like to respond to the comment that was made and the reflections that were made before we come to a close.
I was just
Please.
going to say I agree with the comment on reproductive violence. I think that's why it's important to have as many voices as we move forward to like a final text, because we're not going to be able to think of everything. Yeah.
I might just make a more general comment in response to both questions, which is there's no such thing as a small memo. All of these individual acts that have contributed to getting to here right now, there's just no action too small, right? It might be somebody just speaks to somebody and all of a sudden that lights a spark. And so I think one of the biggest learnings of this process has been every voice matters, and don't think you're too small to make a difference. There's a great proverb. When I worked at the Office of the Prosecutor under Fatou, somebody said, if you think you're too small, and it's a picture of a mosquito, and it said, if you think you are too small to make a difference, you haven't spent a night with a mosquito. And I'll just leave it with that.
Thank you very much. Remember the mosquito indeed. Yeah, please, Akila, go for it.
I'll be very brief. No, this is also, I think, in response to the reflection, because in putting these ideas out, we've gotten so much pushback, but there's been a lot of support, but there's been a lot of pushback. And I think, Jim, what you're reflecting on is also the fact that when we look backwards, we make things seem much more obvious and easy, right? That like you look at the jurisprudence and so you're like, oh, of course, forced marriage, but what a crazy idea on all of these other things. And sometimes you need to remember that when people are pushing back on you and saying, well, why do you have so many crazy ideas? That, it's exactly these kinds of things that when we learn the history and tell the story, that's important. So I think the other thing just to say is I think as we've talked about many different components, I think there's a very important component of this work where we perhaps also need to very deliberately be telling the story continually along the way as well.
Thank you very much. Well noted. Let me then turn back to you, Hazel, for your reflections on this, and perhaps we'll close off with you. Thank you.
Oh, thank you. I'm not sure if it's really my role to respond, but I thought I'd jump in. I thought I'd jump in because the lady's comment at the back about the experiences of the women who then have to give birth made me think of something which we're trying to do in the British Foreign Service, which is bring together all our different tools. And what we've spoken about today are kind of justice pathways and ensuring that we have the right laws in place. But what we actually also need to do is ensure that what we do in our development work, our programming spend, what we do in our security sector work is also all going in the same direction. I don't know if there are other representatives from MFAs here, but I'll certainly be taking that away with me. And thank you for that comment.
Thank you, Hazel. That can be one of the most impactful ways, indeed, where states help this development. Let us leave it at that for today. Much more discussions to be had on my end. I hope that once we exit this room, we'll have the good news that an agreement has been reached on the court's budget for 2025 and that we can all go home. But let's see about that. Thank you so very much also on behalf of all of the other co-organizers of this panel for your engagement and interest in this topic. Again, there are many resources out there. Make sure to go and find them. And then I'll end on what you said, Uliana. This is not just a legal treaty. This is a promise. Thank you all.